All right, Mr. Gatsa, good morning.
Good morning, Judge. I'm here on F 5955-16-8. In the interest of Noah Alexander Pulido, opposing attorney is Mr. Villalobos. He's on the screen. We're set for order setting default judgment hearing. I'm here, Carlos Gatsa, for the respondent, Paul Pulido. Your Honor, we filed a notice of appearance on this case. We're in on it, just that he was never served. I spoke with Mr. Villalobos, and we're going to try to work this out.
All right, so Mr. Villalobos.
Okay, well, one thing that he was actually served, that's why they're here. But Judge, yes, I did speak. Mr. Garza contacted me yesterday. We've actually spoken about a month ago, and when he was going to get a retainer, and he wasn't. But right now, Judge, I understand that he's making an appearance. The only concern I have is this was in fact an emergency motion regarding some type of accident occurred of some sexual abuse at the mall, Judge, that we're concerned about. So I'm not sure how the court would like to address that. And I'm not saying that it's regarding the responding. I'm going to make that very clear. I'm not saying it's regarding him directly. Some other concerns that we have, but I'm not sure whether the court is going to address that or not today.
All right, I don't know anything about it. Do we need to go into a breakout room to discuss this? Or
could we do that, sir? Maybe that might be best. I mean, there's a lot of people. It's kind of a sensitive situation.
Well, Your Honor, if I may, I'd be glad to enter into some temporary orders with Mr. Villalobos. He just needs to, as a matter of fact, I thought he was going to send me an example of the orders that he wanted, and we can knock it out that way. Just submit them to the court under Rule 11.
I don't have any problem doing that, sir, but just in case we can't get something resolved, do you think we might be able to get a quick reset so we can put light of fire under everyone so we can get something done?
Let me do this. Let me put both of you into a breakout room, see if something can get resolved right now while I continue with my docket. And then y'all can let me know if you need my help in any way, and then we'll go from there.
Very good.
Thank you, sir.
All right, please accept the invitation and come right back and let me know how or if you need my help.
Thank you, sir.
All right, Mr. Kettler.
Good morning, Judge. I'm here on behalf of Con Appliances for case number CL 18-2652H. I anticipate that an actual hearing would take less than about 5 minutes. This is a reset for plaintiff's motion for default judgment. The first continuance should have been based off of potential settlement grounds, and the second, I believe, should be as well. I understand, though, this is a very old case, and so if we need to proceed today, then I certainly understand that, but it does look like there might have been some sort of contact from the defendant yesterday to your court. And I don't see the defendant here online.
So Irene Machuca, is Irene Machuca present? If you're on mute, please unmute yourself. Irene Machuca. All right, so she called, she provided her email address. We provided that notice to her. This is a motion for default judgment. She was served back in 2018. There's been no answer. Case was set for 9:30 this morning. Is Irene Machuca present? Irene Machuca, if you're on mute, please unmute yourself. Irene Machuca. Somebody who just logged on. I want to make sure that that is not Irene Machuca. Irene Machuca, if you're on mute, please unmute yourself. Irene Machuca. It doesn't look as if that is Irene. Mr. Kettler, you may proceed with your default.
Yes, Your Honor. And before I do, though, I would like to urge the continuance if I can, even despite the age of this case. Is that something that you would be willing to grant, or should I just go ahead and move forward today?
So you're requesting a continuance. I'm sorry, maybe I misunderstood.
I apologize, Judge. I could have been more clear. There was the principal firm had filed one on March 3rd.
Yes, I have no problem resetting this. April the 6th as a reset date. and submit an order setting hearing so we can give notice to the respondent. And that'll
All
be
right.
April 6th, 9:30.
All right. Thank you, Judge. May I be excused?
Yes, you may. Thank you. All right, Ms. Della Fe Pettis, are you available?
Yes, Judge, I'm available. I'm here.
All right.
I'm here on P00612228. It's a protective order, and I represent the applicant, Amanda Denise Alvarado. She is on the Zoom hearing as well. And Judge, the respondent has not been served yet, so I wanted to request an extension and request additional time so that we can get him served.
Your extension of your ex parte protective order is granted.
Thank you, Judge.
March 23rd, 2022 at 9:30 is the reset date.
Okay, perfect. That's all I have before the court today, Your Honor. May I be excused?
Yes, ma'am.
All right, thank you so much.
Thank you.
Bye-bye.
Mr. Benz, what do you have?
Good morning, Your Honor. I'm here on cause number CL -21 1732. We're set for a summary judgment hearing today. I'm not aware of a response to the summary judgment being filed. I do not see the filing attorney, Daniel Simmons, in the courtroom, nor do I see the defendant, Sergio Gasa. So we have a summary.
Judge, I'm Stephen Fox, and I'm here for Mr. Cement.
I apologize, Your Honor. I'll take my hand down and wait my turn, Your Honor. I apologize.
All right. I suspect that this is a summary judgment, so it's not a quick announcement, and I'll call you guys here shortly.
Yes, sir.
All right, Mr. Guerra, your announcement.
Your Honor, I'm here on cause number CL 22-05768. Heriberto Castro. I'm working with the opposing counsel is Patrick Moore. On my petition, I said that they just needed more time. He is aware of that. The petition, it even names the person that he contacts to see that the closing is moving forward, where his client will get paid. And so he's aware of all this. We're going to be able to hopefully close on the March 18th. So you can either expire by operation of law or just reset it, whichever the court wants to do, Your Honor.
All right, is Mr. Patrick Moore or any representative for Row 2 Investments LLC present?
No, because they haven't gotten served, and so he didn't want to waive service. And I said, I mean, that's fine. I said, it doesn't matter as long as we move this thing forward. And so that's where we're at, Your Honor.
All right, well then let me let the TRO expire by operation of law.
Okay, can you just quickly put us a status here, Your Honor, so it won't linger, maybe 30 days down the road, and that way we can make sure that it doesn't, you don't keep it on the books.
All right,
Maybe I'll start
reset
here.
for a, I guess it could be a reset for a DWAP on August 6th. Oh, I'm sorry, what date? April 6th, I'm sorry, April 6th, 2022 at 9:30.
And it's for a DWAP, Your Honor?
Yes, for a DWAP.
That's fine. Perfect, Your Honor. Thank you so much. May I be excused? That's all I have.
Yes, you may, thank you.
Stay safe, yeah, Judge. Bye.
All right, Mr. Guerra, what do you have?
Judge, I have a divorce prove-up matter of the marriage of Karina Hall and Terrence Hall in your civil docket.
All right, that's F 4749-21-8 in the matter of the marriage of Karina Hall and Terrence Hall. Are you ready to proceed on that?
Yes, Your Honor. Both parties, there's a waiver of service filed by Mr. Hall. Ms. Hall is here to prove it up, and an agreed final divorce decree has also been signed by both parties and filed on February the 14th. If I could just ask Ms. Hall some questions, Your Honor, I can prove it up real quick.
Sure. Ms. Hall, can I have you raise your right hand, please? Do you sort of tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed, Mr. Guerra.
Thank you. State your name for the record, please.
Karina Hall?
And you're presently married to Mr. Terrence Hall?
Yes, sir.
Have you been in domicile or Texas for the preceding 6-month period? Any resident of this county for the preceding 90-day period?
Yes, sir.
Were you married to Mr. Hall on or about May 9, 2009? And did you cease living together as spouses on or about April 27, 2017?
Yes, sir.
Has your marriage to Mr. Hall become insupportable because of discord of conflict of personalities that destroys the legitimate ends of the marriage relationship?
Yes.
Is there any reasonable expectation of reconciliation?
No.
Are there children under 18?
Yes.
Their names and ages?
Terrence Lamar Hall, 14, and Camila Gloria Hall, 10.
Okay. Were any children adopted?
Yes.
Any minor children?
No, I'm so sorry. No.
Okay. Are you expecting any children at this time?
No, sir.
Okay. And were there any court order relationships, guardianships, or court order relationships affecting the children before this divorce proceeding?
No, sir.
Do the children own any property?
No.
And have you and your husband signed off on the agreed divorce decree that's on file with this court?
Yes.
Okay. And in that, you did agree that both of you be appointed joint managing conservators. Is that correct?
Yes.
That he gets standard visitation?
Yes.
And as far as the child support, it is agreed that no party will owe child support to the other party due to the petitioner, which is receiving Social Security, disability, and VA caregiver support benefits from the respondent for the benefit of the children.
Yes.
Okay. And he's also responsible to pay for the insurance premium?
That's correct. Yes.
Okay. And both of you agreed that you would keep all sums of cash in your possession or subject to your control. Is that correct?
Yes.
All insurance, pensions, retirement benefits, and other benefits arising out of any membership of any employment. Is that correct?
Yes.
That you would keep the 2016 Chevy Impala.
Yes.
Is that correct? Okay. And that you keep all personal items in your possession subject to your control.
Yes.
And that Mr. Hall keeps all the sums in his possession. Is that right?
Yes.
That Mr. Hall will keep the 2015 Ford F-150 Ford motor vehicle
Yes.
and all the possessions in his possession he will keep. Is that correct?
Yes, that is correct.
Are you asking and that he be responsible to pay for any debts on the 2015 Ford F-150? Is that right?
Yes.
Okay. And are you asking for? You're not asking for a name change, correct?
No, not at all.
Okay. And you are asking this court for divorce?
Yes.
Judge, I have nothing further.
All right. Court's going to take judicial notice of all documents in the court's file, including the filing of this action on October the 27th of 2021. A waiver was executed by the respondent. Terrence Hall on December 27, 2021. Court's going to go ahead and grant the divorce along with all relief that's been read into the record and prayed for by way of pleadings. Your divorce is hereby granted, Ms. Hall. Good luck to you. Since an agreed divorce is already on file, you should be able to get a certified copy this afternoon.
Thank
Thank
you.
you, Judge.
Thank
May we both be excused?
Yes, ma'am. Yes, sir. Thank you.
Thank you.
Thank you.
All right, Mr. Garza, you have an announcement?
We do, Judge, Mr. Villalobos has an announcement.
All right.
Your Honor, we've conferred and we've reached pretty much an agreement regarding that we will have supervised visitation and that we will keep the away from wherever they need to. We'll put that in writing for the court. We'll be submitting it by the end of the day.
Perfect.
May we be excused, Your Honor?
You both are excused. Thank you so much. Rule 11.
Thank you,
Yes, sir. You have a great day, sir.
All right, in court, I have several attorneys. I have Mr. Ortegon, and I know Mr. Barrera is logged on. Mr. Ortegon, do you mind going into our jury room? And we have a computer set up in there for you. No problem. Yeah. Thank you so much. Mr. Barrera, give me 1 second while Mr. Ortegon goes and gets set up in the jury room.
Good morning, Judge.
Good morning.
Good morning, Your Honor. Good morning, Mr. Barrera.
Morning. Judge, we have a final hearing on this case. And I believe that there was an exchange of property that occurred yesterday. My client gave the property that Mr. Ortegon's client wanted. We haven't gotten a status on that, but everything is pretty good.
We're ready,
Everything-
we're ready to prove it up. I hate to interrupt, Mr. Barrera. I did speak to my client. We're ready to prove it up, Your Honor. We took care of the last issues yesterday. We are planning on signing the decree and sending it to Mr. Barrera's office this afternoon. We have been provided with a decree as well as a deed, Judge, that we have reviewed, and we're ready to sign and submit, Your Honor. We are ready to prove it up. That was, we settled that. We took care of that issue yesterday, Judge.
Okay, so, yeah, if the current decree is okay, Judge, then we're okay with that. I know there was an issue of an appraisal in the house, but I'm assuming that got worked out. And
It got worked out, Your Honor, and I do have a couple questions for my client regarding that on the record. However, those issues did get worked out, Your Honor.
okay, Judge, we're ready to prove it up.
If I can have Mr. and Mrs. Hernandez, I think I have a JJ Hernandez and a Marla Hernandez. Please unmute yourself. And if you can both, please raise your right hands. Do each of you sort of tell the truth, the whole truth, and nothing but the truth, so help you God? I'm going to start with Marla Hernandez
I do.
and Mr. Juan Hernandez.
I do.
Thank you. Who would care to prove this up? Mr. Barrera, Mr. Ortegon?
Judge, I can go first if you'd
Go
like.
ahead. Go ahead.
Okay, Ms. Hernandez, can you please state your full name for the record?
Marla Audelia Hernandez.
And you're presently married to Juan Joel Hernandez?
Yes, sir.
Okay, and you've lived in Texas for the last 6 months and in the county for the last 90 days, is that right?
Yes, sir.
Okay, and you were married to Mr. Hernandez on or about April 4th, 2017, is that right?
Yes.
And y'all ceased living together as husband and wife on or about April 9th of 2021, is that right?
Initially, yes.
Okay, and then y'all got back together, and then recently in December, I believe, of 2021 is when Mr. Hernandez moved out permanently, is that right?
Yes, sir.
Okay. And so your marriage to Mr. Hernandez has become insupportable because you all cannot get along and it does not foster your ability to stay in your marriage. Is that right?
Yes.
Okay. And is there any reasonable expectation that you all will get back together?
No, sir.
Okay. And were there any children born to your marriage?
Yes.
And was that Jackson Marcus Hernandez, your son?
Yes, sir.
Okay. And there has been no children that have been adopted by you and Mr. Hernandez. Is that right?
No.
And are you expecting a child at this time?
No, sir.
Okay. And there hasn't been any court-ordered conservatorships or anything related to your child prior to this particular case. Is that right?
No. Mm-mm.
Okay. And does your child own any property?
No.
Okay. And so you and your husband have entered into agreement concerning the conservatorship in support of your child. Is that right?
Yes, sir.
Okay. And those numbers are contained in the decree that we have sent over to Mr. Hernandez and his attorney to review and sign off on. Is that right?
Yes.
And so the amount that y'all have determined that is owed in child support is $796.52 a month. Is that right?
Yes.
Okay. And there's that was to start on February 1st, 2022. Is that right?
Yes.
Okay. And Mr. Hernandez has paid you $400 that applied to those to that February and March amount. Is that right?
Yes, sir.
Okay, so the amount for February and March was $1,907.04, and if you subtract the $400, then the arrearage is $1,507.04 for February, March of 2022. Is that right?
Yes, sir.
Okay. And do you believe that that this agreement between you and your husband is in the best interest of your child under the circumstances?
Yes.
Okay, and you and your husband have entered into an agreement concerning the division of your property and debts. Is that right?
Yes.
And that's contained in the proposed final decree of divorce that we've sent over to your husband, Mr. Hernandez. Is that right?
Yes, sir.
Okay, and are you requesting that your name be changed from Marla A. Hernandez to Marla Audelia Rodriguez?
Yes, sir.
Okay, and under the circumstances of your divorce, do you feel that that the division of property is fair and equitable under the circumstances?
Yes, I do.
Okay, and are you asking the court to grant your divorce and approve all the agreements you have entered into contained in the proposed final decree of divorce that we've sent to your husband, Mr. Hernandez, and his lawyer, Mr. Ortegon?
Yes.
I'll pass the witness, Judge.
All right, Mr. Ortegon, any questions?
No questions for Ms. Hernandez, Your Honor. I do have questions for my own client.
All right, you may proceed.
Mr. Hernandez, will you please state your full name for the record?
Juan Joel Hernandez.
Okay, and you understood and listened to the questions that Attorney Barrera asked Ms. Marla Hernandez. Is that correct?
Yes, sir.
Now, are you in agreement to her responses? Are you in agreement with her responses?
Yes.
Okay, now, under the circumstances, we did, we have discussed the final decree as well as the custody agreement with your child. Is that correct?
Yes.
Now, do you believe that that agreement is in the best interest of your child at this time under the circumstances?
Yes, sir.
Okay, now the division of property, you understand that you will be signing a deed granting over the property to Ms. Hernandez. Is that correct?
Yes, sir.
However, she is to assume the debts related to that property. Is that correct?
Yes, sir.
And that includes some Lowe's debts and some other debts that we discussed in my office. Is that correct?
Yes, sir.
And you understand that you will be signing a deed, deeding over her that property and ridding yourself of any interest in that property going forward. Is that correct?
Yes.
Now, we've had ample time to discuss this, and I've made you aware that we have a right to request an appraisal on this property. However, you've informed me that you want to go forward and just finalize this divorce. Is that correct?
Yes.
Was that decision made freely and voluntarily?
Yes.
Now, are you coming to an agreement on this case freely and voluntarily?
Yes.
And do you believe that the agreement under the circumstances is fair and equitable to both you and Ms. Hernandez regarding the property in this case?
Yes, sir.
Are you happy with the services and advice I've provided you as your attorney in this case?
Yes.
Have I answered all your questions?
Yes.
Are you respectfully requesting that this honorable court grant your divorce?
Yes.
And you will be coming into my office this afternoon to sign the final decree that we've reviewed. Is that correct?
Yes.
Judge, at this point, we have no further questions. I pass it.
Mr. Barrera, do you have any questions for Mr. Hernandez?
No, Your Honor, I think we're ready to finalize.
All right. Court's going to go ahead and, so no other questions, Mr. Ortegon or Mr. Barrera, for any of the two witnesses?
No, Your Honor.
No, Your Honor.
All right, court's going to go ahead and take judicial notice of all documents in the court's file. The court's going to go ahead and finalize the divorce, along with all relief that the lawyers have put into the record. Your divorce is hereby finalized. Has an order been submitted by either of you? No, correct?
Submitting it today, Judge.
All right.
Yeah, we just need to sign off on it.
That's correct, Judge. They've sent it to me. We've reviewed it. We were just, there were some issues we took care of yesterday. We're going to go ahead and get that signed, and I will send it back to Mr. Barrera for signing. I believe his client still needs to sign it, so we can go ahead and get it filed with this honorable court.
All right, thank you so much. Good luck to Mr. and Mrs. Hernandez. Now, Ms. Rodriguez, good luck to both of you.
That's
Thank
all
you,
I have, Your Honor. May I be excused?
Yeah, the four of you are excused.
Thank you, Your Honor.
All right, I have Mr. Ortega, who is here on CL 220550H. It's PRO. Mr. Anthony Ortega You're on mute right now. You're here on Miriam Araceli Hernandez versus Vel MEJ LLC.
Right, Judge Velme.
Okay.
This TRO was filed by Mr. Hernandez, I believe pro se. This was a case that was heard in court for where a judge ruled in our favor for my client to have possession of the property. Then it went up on appeal. She was at that time represented by Mr. Juan Angel Guerra. The appellate court confirmed the decision, sent it back down, and court 4 issued a writ of possession to my client. Once he went and tried to execute on the property, he learned that she had filed for a TRO pro se. I have not seen her. I don't know that she's present or here, Judge.
Is
Or
Miriam Araceli Hernandez present? If you're on mute, please unmute yourself. Miriam Araceli Hernandez, if you're on mute, please unmute yourself. Miriam Araceli Hernandez, please unmute yourself.
Judge, and on the original petition, there was an email for her. I did send it to her.
Right, it seems that an email was provided and we did send notice to her. What is your request at this time, Mr. Ortega?
Judge, we're opposed to the TRO. We're asking that you dismiss the TRO and grant possession to my client in this case, Judge.
Again, Miriam Araceli Hernandez, if you're on mute, please unmute yourself. All right, the TRO is hereby, I guess it's denied. And the writ of possession, I guess you already have the writ of possession, correct? So I wouldn't be granting a new writ of possession. I'd just be allowing you to execute on it based on the TRO being denied.
Right, Judge. My client went with the constable to execute it, so we've still got it. We would just go again to try and execute on it.
Sounds good. Well, the TRO is denied.
Great. Thank you, Judge.
You're welcome.
May we be excused?
You're excused. All right, Mr. Pequeño, I have Mr. Rigney who's present here. Mr. Rigney, are you available to maybe have that quick hearing? He is, Mr. Pequeño, Mr. Rigney is present here in the courtroom, but in the jury room, we have the computer set up.
Good morning, Your Honor.
Good morning.
And just for the record, we're here on cause number CL 187130-H.
Yes, this is Kemas Far Jackson Ltd. versus Valley Mattress Sales LLC and Richard Finney. This is the case where I believe Mr. Finney has deceased, and there were some issues about whether or not the estate was going to maybe have some liability. And then I think, if I'm not mistaken, I may have suggested about you all going and mediating and then coming back today to see if that was even going to be a possibility. I'm assuming that's what today's status hearing is?
Yes, that's correct, Judge. We're basically set for a status, and just for the record, again, Juan Pequeno for the defendants in the case. Yes, Mr. Feeney's deceased, as we mentioned last time. We presented some argument on some summary judgment, the plaintiff's motion for summary judgment. We did kind of discuss and explore the possibility of possibly mediating, Judge, but I think the parties would be too far apart. And so in discussing with Mr. Rigney, I indicated that it likely wouldn't be fruitful. So I think our only announcement, I guess, to the court is, a motion for summary judgment has been filed. We filed our objections in response. We'd asked the court to make a ruling on that. The only, I guess, I'd like to make clear is as far as, Richard, the defendant, Richard Feeney, since he is deceased, again, as per the rules, and my understanding was that that wasn't moving forward at this time, but as per the rules, his estate essentially needs to be brought into this proceeding before the case can move forward.
All right.
At least as to him, I guess I should clarify.
Mr. Rigney, you're on mute, so if you don't mind unmuting yourself in case you would like to share some information with the court.
Yes, Judge, thank you. Yes, Judge, so since mediation would not be fruitful, I just would like to move forward on my motion for summary judgment. And at this time, what we're asking for is really just a partial motion for summary judgment on Valley Mattress Sales since Mr. Finney has passed away.
I know we had spoken about me holding off on making a ruling. Do you all have anything else to add before the court makes a decision or rules on it later today or this week?
Not at this time, Judge. I think we covered a lot of the arguments last hearing fairly
Sure,
thoroughly.
no, yeah, I remember those. I just didn't know if y'all wanted to add anything real quick.
Yeah, I mean, yeah, I would just, refer the court to, again, we asserted several objections. I did submit a proposed order on my objections along with a proposed order. I'm not sure that Mr. Rigney filed a proposed order as well, but I think everything's pretty much set out in what we filed with the court.
Perfect. I was just about to ask whether or not orders had been submitted. I know, Mr. Rigney, if you're requesting a partial MSJ, did you submit a partial order on an MSJ?
No, Judge, I need to submit an order. And so it's, like I said, it's partial only because it's against Valley Mattress Sales only.
Perfect. All right, if y'all, I already have Mr. Pequeños, Mr. Rigney, if you can submit an order, and then let me review the file once more. I'll go back and look at the old video. It's much quicker than requesting a transcript. I just go back and watch old videos and hear arguments all over again. So you'll have a decision by the end of the week.
Thank you, Judge. That's all. May we be excused?
Yes, thank you.
Thank you, Judge.
All right, let me see who else is available and ready. Mr. Fox, are you ready to? We have a Mr. Benz and Mr. Fox.
Yes, Judge, I'm ready.
All right. Now, let me see, Mr. Benz, which case are you all here together, right, Mr. Benz and Mr. Fox?
No, sir. I believe we're on the opposite end of the case, Your Honor.
Yeah, but together on the same case.
Yes, sir. That's my understanding.
Okay, I just wanted to make sure. All right, let me go back to that case. Is this Security First Federal Credit Union versus Sergio Garza?
Yes, sir.
All right. This is CL 21-1732H. And Mr. Benz, is this your summary judgment?
That's correct, Your Honor.
All right, I'll allow you to proceed.
First and foremost, Your Honor, I respectfully request I be allowed to appear on behalf of lead counsel for this matter, Your Honor. I also request the court take judicial notice of any and all documents in court's physical file or electronic file. Your Honor, this is a summary judgment associated with the deficiency of a repossessed vehicle. This has to do with in November of 17, the defendant financed approximately $75,000 for a 2018 Ford vehicle. The payments were to begin on January 8, 2018. The payments terminated on March 8, 2024. It's our position that the defendant ceased making payments in February of 20. The vehicle was repossessed in May of 2020 and sold at auction on June 12, 2020 in the amount of $34,750, which we take the position was the higher end of the auction amount at the time, leaving a deficiency balance in the amount of $20,845.60 as of September 4, 2020, accruing at 7.5% plus interest and attorney's fees and costs. Your Honor, we've submitted a series of exhibits in furtherance of our position, effectively proving of our position that the agreement was entered into, that the vehicle was repossessed, that it was auctioned off, and that there's an outstanding balance. Before we address the defendant's affirmative defenses, I think procedurally it would make sense for the defendant to have an opportunity to respond to our initial claims, and then we'll discuss or address their affirmative defenses, Your Honor.
All right, Mr. Fox, you're on mute.
Yes, Judge. Judge, in order to have a valid motion for summary judgment, the movement must marshal facts that would be admissible in a court at law. And if the if the movement relies on affidavits per Rule 166A5 under form of affidavits, further testimony, supporting and opposing affidavits shall be made on personal knowledge and shall set forth such facts as would be admissible in evidence. In other words, if the witness was actually sitting in the witness stand before the court now, this testimony by this particular witness would in fact be admissible. Now, the plaintiff in its motion for summary judgment is relying on documentation. And we would submit that the documents that the plaintiff has submitted in this case do not pass the hearsay, do not make any exception to the hearsay rule. Now, with documents, the rule that it would have to comply with would be Texas Rule of Evidence 902 parenthesis 10 close parenthesis B close parenthesis. In other words, 902.10b, elements 1 through 6. Now, the defendant in this, the plaintiff in this case does submit what it purports to be an affidavit signed by, let's see, an Arnold Soto. Let's read what Arnold has to say in his affidavit. Arnold says that he's the custodian of the records of plaintiff. And he says attached here to are 28 pages of records from plaintiff. These 28 pages of records marked as exhibits 1 through 9 are kept by plaintiff in the regular course of business. And it was the regular course of business of plaintiff for an employee or representative of plaintiff with knowledge of the act, event, condition, opinion, or diagnosis recorded to make the record or to transmit information thereof. And then he says exhibits 1 through 9 are made at or near the time of the events depicted thereby or reasonably soon thereafter. Exhibits 1 through 9 are the original or a true and correct copy of the originals. Exhibit 1 through 9 are incorporated herein by reference for all purposes. That's wonderful if Texas Rule of Evidence 902.10b only had 4 elements. However, the rule has 6 elements, and here's where Arnold fails to make this a business record exception to the hearsay rule. Number 5, the records were kept in the course of regularly conducted business activity. No such statement found in Arnold's affidavit. And number 6, it is the regular practice of the business activity to make these records. Again, Arnold makes no such statement. Therefore, Arnold's affidavit that's submitted to get these 28 pages of records, which are their exhibits 1 through 9, into evidence, does not pass muster per the business record exception to the hearsay rule, which is one of the 29 exceptions to the hearsay rule. But that notwithstanding, we have another problem. We've challenged plaintiff's motion for summary judgment based on the fact that plaintiff cannot show, or he can't show that there's no genuine material issue. There's no genuine issue of material fact and dispute as to whether or not this repossessed car was sold in a commercially reasonable manner. Here's what we have to say about that, and it is found in our response to plaintiff's motion for summary judgment. Under disposition of collateral after default, the second paragraph, whether the secured party endeavored to obtain the best possible price. The collateral is sold in bulk or piecemeal. It is sold, this is talking about the 9.504C factors under the Texas Business and Commerce Code, or under the Uniform Commercial Code, which would be again 9.504. These are some of the factors that are to be considered in whether or not plaintiff can meet its genuine burden to show that there's no genuine issue of material fact in dispute as to whether or not this repossessed car was sold to obtain the best possible price. And yes, we do have a problem with that. Per its plaintiff's records, which are really not before the court, as they don't pass muster under 90210B. But even if you look at those documents, it shows that the Houston Auto Auction inspected the vehicle and found that it needs $1,850 to fix a few things that would bring a higher price. Plaintiff chose not to spend that money and didn't make those repairs, and therefore the vehicle didn't bring such a high price. So again, I think that we have shown that there's a genuine issue of material fact in dispute in this case, which defeats plaintiff's motion for summary judgment. First of all, there's no competent evidence before the court because those documents are hearsay. That is, those documents are statements written down or made outside the courtroom that are now being offered inside the courtroom to prove the truth of the matter asserted. And it can't do it unless you meet all 6 elements of Texas Rule of Evidence 90210B 1 through 6. Arnold meets elements 1 through 4, but fails to meet elements 5 and 6. And therefore, those documents are not properly before the court because they are hearsay, but also because we've raised the issue, a genuine issue of material fact and dispute in this case, as to whether or not the vehicle was sold at the Houston Auto Auction in a commercially reasonable manner. And in this case, I think we've raised that genuine issue of material fact. The plaintiff could have put a little money into it, got the dents, scratches, chips, and paint issues taken care of so that it would have brought a higher price at the Houston Auto Auction, but failed to do so. All they did pay for, I think, was about $70 or $75 for a wash and wax. And so I think, and by the way, by paying for the wash and wax, I think plaintiff has shown that it understood it did need to do something to get this car in good shape to bring a higher price, but didn't do what the auto auction inspector thought it should have done to bring the highest possible price in this matter. So I think that the court should deny plaintiff's motion for summary judgment.
Brief response, Your Honor.
Go ahead.
First and foremost, as to the affidavit, Your Honor, of it being insufficient, and this is a standard typical affidavit that's accepted across courts all across the nation. If there is an issue, if the court determines that 5 and 6 is missing, we don't believe it is. We believe we've met the business records affidavit standard, then that's fine. We'll refile the summary judgment again, and we'll make sure that 5 and 6 are in there. We'll go through this again. As to the issue defendant is making about a total of $1,800 in repairs, that's less than 10% of the outstanding deficiency, Your Honor. The court can weigh defendant's argument about whether less than 10% of the outstanding balance would have made that big a difference in the possible amount that this asset would have sold for less than 10% of the outstanding balance. And the court can make that determination that less than 10% would have made that big a difference in the highest price being brought, Your Honor. Beyond that, we stand on the affidavits and we stand on the evidence.
Judge, in brief response, I think plaintiff has misconstrued my argument about.
We don't believe there's a genuine issue of material fact in light of the arguments that are being made for the record, Your Honor.
All right, Mr. Fox.
Oh, yes, Judge, I'm sorry. I didn't mean to interrupt. I didn't mean to interrupt you, Travis. Sorry about that. But Judge, I think Travis is misconstruing my argument about having to pay an extra $1,850 to get the car fixed up in order to bring the best possible price at the Houston Auto Auction. But as to the business record portion of Arnold's affidavit, Travis is located in Houston. He's in a major law firm, I think in one of the 3 Allen or 2 Allen Center in downtown Houston. And so he knows the Texas rule of evidence probably better than most of us in this courtroom right now. So all Travis had to do is basically copy elements 1 through 6 in that portion of Arnold's affidavit and get Arnold to sign it, which he failed to do. He just copied elements 1 through 4. And the elements 1 through 4 doesn't get it. You need all 6 elements to meet the business record exception to the hearsay rule. And so those documents that have been submitted by plaintiff in support of its motion for summary judgment are not properly before the court as per the rules on summary judgment, which I read to the court initially, but I could read again. It's under 166A, I believe, F, if I'm not mistaken. But at any rate, if Arnold was sitting in the witness stand and testifying, just as he's testifying in his affidavit, he would not meet 902.10b 1 through 6. He would only meet 902.10b 1 through 4. And so so the court would not, I don't believe, accept those documents in evidence as an exception to the hearsay rule, which would be the business record exception to the hearsay rule, because Arnold simply doesn't make it. Now, Arnold can, as Travis said, Arnold can, if he wants to, re-sign an affidavit. Yeah, that's right. It's 166A-F, form of affidavits, further testimony. But again, you still have the problem of, the Houston Auto Auction inspector inspected the vehicle, says, look, we need to make a few repairs here. It's going to cost $1,850. And plaintiff said, no, it's not about taking $1,850 off the deficiency amount. That's not the point. The point is, had they put the car in a good condition and spent the extra $1,850, they could have received a much higher price for the vehicle and therefore would be suing defendant here for a much lower amount, if at all.
Now, Mr. Fox, are they required to do that? Is that a requirement that they try to seek to minimize any damages to the vehicle to maximize the sell price to minimize the deficiency? Is that a requirement?
Yes, under Texas Business and Commerce Code, section 9.504C, it requires a seller to endeavor to obtain the best possible price. And I think that would actually have gone to getting the best possible price. But in this case, they just paid for a wax and cleanup for $75 and that was it. And so they didn't get the best possible price, which goes to the issue of whether or not this repossessed car was sold in a quote unquote commercially reasonable manner. And Judge, this isn't the trial of the case. This is a motion for summary judgment where the plaintiff has the burden of showing that there's no genuine issue of material fact in dispute, but we have raised a genuine issue of material fact in dispute as to the sale of the vehicle and also whether or not plaintiff's documents are even before the court in evidence.
Brief response, Your Honor, very brief. First and foremost, Your Honor, while I appreciate Mr. Fox's representation that I'm some big city lawyer, I'm a lot of things lawyer, Your Honor, but I'll never claim I'm a lawyer from Houston. I'm a South Texas lawyer. I'm run-of-the-mill and ordinary. I'm no big city lawyer. Your Honor, as to the defendant's claim about plaintiff not getting the most commercially reasonable manner, what he's opened the door, he's taking that position. This thing goes forward. He now gets to prove, now that he's taking the position, of how much more we would have gotten had we spent the $1,800 to fix whatever we were supposed to fix. And I look forward to them proving how exactly they're going to do that.
All right, Mr. Fox, Mr. Benz, thank you so much. Please submit your competing orders and the court will have a decision by Friday.
Your Honor, that concludes my business for this honorable court. May I be excused?
You're excused. Thank you.
Thank you, Judge.
Thank you. All right, Mr. Jared Hall, please.
Good morning, Your Honor. I am here on Geico versus Daniela Alejandra Gomez. This is cause number CL-20-4282-H. We had this set for a motion for default judgment hearing.
All right.
I was going to initially pass this because service is defective, but I also see just about 30 minutes ago, counsel for Ms. Gomez has filed a motion to quash the service basically for the same reasons.
Correct, Your Honor. Good morning. Rene Castellanos for the defendant, Ms. Gomez. I initially represented Mr. Garibay and just need to confirm that a non-suit was filed on that as represented to the court. And then I also represent Ms. Gomez and filed a motion to quash service, Your Honor.
So we're okay with that. I guess we're going to get the citation corrected, get her reserved, and then I believe the court has signed the order as to Daniel Garibay, so he's out of the case. So we'll get that citation reissued and proceed.
All right. So then basically no action today. And Mr. Castellanos, I suspect that when she's properly served, Daniela Gomez, you'll be probably most likely making an announcement on that case.
If the court wants to take that route, that's fine. Judge, normally it's a constructive appearance. So it's just granted additional time for her to answer. She doesn't need to be reserved or served, I should say.
Okay. I mean, if you're okay with that, that's perfectly fine. So we just reset this for say 21 days?
21 days, that's correct. The Monday after 20 days expire, yes.
So I take it you will be filing an answer on her behalf here sometime in the next 20 days, or?
That is correct, yes.
Okay, then we'll just hold off on, then we don't need to go get service and go through all that then. I guess that'll clear that up, make it easier for all of us, and then we can proceed in regular order here.
All right, April 4th, because I think the 20 days lands on a Monday, so we'll go to the following Monday, so April 4th.
Judge, I'm sorry, I'm going to be in trial on that day in Cameron County on that Monday.
April 6th?
We can do it latter part of the week before or the week after, or I'm sorry, that same week, just not on that Monday.
Yeah, how about the 6th of April?
That would be fine, Judge.
All right. We'll do April 6th.
Yeah, what time, Judge?
9:30.
9:30. Okay, that should be fine for us.
If not, I can go to the following Monday.
That would be fine too, Judge. I just can't on that week.
The following Monday actually works better for me because I'm more clear that day.
All right, the following Monday is the 11th, April 11th, if that's okay with both of you?
That'd be fine, Your Honor.
Perfect.
9:30 as well?
9:30.
Okay.
Okay.
May I be excused, Your Honor?
You're both excused. Thank you.
Thank you.
Mr. Davis, what do you have?
Good morning, Judge. I'm here on F033122-8. It's a temporary orders on a divorce case. Ms. Olivares represents the respondent.
Yes, good morning, Your Honor. We're here, Mr. Raimundo Garza and myself on that case of Maria del Rosario Garza and Raimundo Garza. I did send, while we were waiting, I sent Mr. Davis a text and see if he agrees that both stay in the house and take care of their children that have a disability, Judge. They're adults, but they need help.
Right, no, and the issue with that is these are adult children. They're disabled, but they're not before the court. So I don't think Your Honor they're not in your case. So there's no jurisdiction as far as this divorce case. I don't know if perhaps they could reach some type of agreement via mediation or whatnot regarding that. And the issues we're having as far as our request for temporary orders, everybody's still in the house and that's not working. They have a joint checking account that we're asking that Mr. Garza make his own checking account and pay his own bills out of his own account. That he not withdraw any money from his 401k while this case is pending. So the big thing is who's going to leave the marital residence. My client lives there. He lives there. There's two disabled adults that are my client's siblings that live there. And then there's two adult children of the litigants that live there as well. My client is, as I understand, they're each a provider for one of the children, but she's actually going to be the provider for both starting next month. And she's the guardian with regards to Social Security. They get a disability payments. I don't know, Judge.
Your Honor, and Mr. Tim Davis is correct about the adult, but I had instructed my and I didn't see the caption to be add those children. They are in the body of my pleadings. I have it on page 2, children of the marriage, those two kids. And the reason we didn't add it on the top because that was the caption he used. But when they're
not minors, they're not minors.
If I may finish, yes, but they're incapacitated children that are considered. They can be either parent can pay child support on a disabled child.
Right.
If I may finish, let me address the court, Mr. Davis, please.
All right.
Your Honor, and so I will amend just to put them back on the caption, to put them on the caption. We can have a hearing maybe. I've got a medical, it's a medical, I guess I could call it, not a report, it's so small, but this is what they gave my client, that from Dr. Samuel Garcia from here, their family doctor, and he says the children are intellectual disability. They have an intellectual disability. They don't understand. One is in a wheelchair. So in the pleading of my pleadings, the children are before the court. They're here. Even though I see Mr. Davis shaking his head, but we all are aware that when there's a disabled child, then that child can be provided child support for life. Now, if they have Social Security, well, they'll give offsets and credits to either parent. But since these children, Judge, are very attached to both parents, one of them is very attached to dad and the other one is very attached to mom. The problem here, the reason they're not agreeing is because Ms. Garza brought in their two brothers, her two siblings who have the same disability. So it might be genetic. She's taking care of two people, a brother, and I have it in my pleadings, and a sister who are also disabled. It's impossible for her to care, and she's their provider under the law. So if she's providing for these two, she cannot provide for her two children. So now she has 4 kids, I'll call them kids, all of them, the brothers and the sisters, that she's providing for. And that's why Mr. Garza needs to be there, because these children are very attached to their dad. The other issue that I had, Your Honor, is that they should not be taken to Mexico. She travels a lot to Mexico. I think she's building a home over there in Mexico. And what's the town they go to? Cerralbo, Nuevo León. And it's very dangerous up there. And these girls go with her. So if she's going to go, to please leave the children at home. Now, I'm before you, Judge, we're before you to see what we do. I really believe that the two parents need to take care of these girls because she's got 2 others. So tell us, guide us, Your Honor, what we need to do.
Mr. Davis, any response?
Judge, just that, I mean, the children are adult disabled children, and I understand that there can be a support obligation that goes on for the life of the children, but even in that case, the court doesn't have jurisdiction over conservatorship, visitation, possession, and access of an adult child. So that's what Ms. Olivares is talking about. She wants relief. She wants you to give her relief that my client not take the children to visit in Mexico. But again, that's up to the guardian of the children. That's up to the children. There's been no determination that they're incapacitated. They do have disabilities.
And there's been no guardianship established, correct?
Not here, Your Honor, not at all for the kids. And I think that's probably one of the answers.
Perhaps, yeah. I don't know this, the severity of their disabilities, if a physician would certify that they're incapacitated. So I agree with that.
Right, and therefore the need for a guardian, so therefore therefore that we would follow the guardianship's orders as to possession, access, and travel, et cetera, et cetera.
That is correct, Your Honor. I agree with that.
Okay, so that's homework issue number one, right? Issue
Yes.
for the court today is whether or not who's going to stay in the home and whether we should allow the parties to, one party to stay in the home versus the other, and or force the parties to cohabitate. And that's the bigger issue, right? I mean, that's the issue before the court.
Yes, you,
Yes, sir.
And
Yes,
so,
Your
Ms.
Honor.
Olivares, would you agree that there has been some conflict between the two parties?
no, no. The conflict that she creates is because of the brother and sister. They do not fight about themselves. They've been taking care of the children. They came from Washington, Your Honor. They lived all their life in Washington. They just got here and they were here. I don't want to say, because I'm not sure if that's correct. There was an issue up in Washington, so they came down here. I don't know if it was with a wife, the IRS, or el problema que vino de Washington. There is an issue, and I don't know what it is, Judge. That's why they relocated to Texas, but they go back to Washington. All their documents are from Washington, the providership and everything. So I say, Judge, to give us a time so they can stay in the house, or send them to counseling, the parents for parental classes if they don't get along, or she removes her siblings. But I mean, I do feel sorry for the siblings too, because they don't have anybody. And my client doesn't mind, but I think it's that conflict that's creating her, because she can't take care of all of them. And the last thing I want to say, Judge, Ms. Garza has a issue with her physical. She's sick and she needs to have an operation, and she won't go. And let me look at my notes.
That's not really
While
before
Mr.
the
Davis,
court.
hold on, Mr. Davis. While Mr. Davis respond, I'll tell you what the problem is, that she needs to seek medical help, care as soon as possible.
All right, but Ms. Olivares, how is that relevant here?
Because then if she doesn't take care of herself, she could get very ill.
Well, if I don't check my sugar on a daily basis, I could get ill too.
Okay, well, let me tell you what she has. That way the judge will understand. If I can address my client here. ¿Qué es el problema con su esposa?
Ella se hizo un tummy tuck en el estómago y está liqueando mucha sangre por dentro.
She did a tummy tuck in the stomach, for the record, and she is leaking blood.
Ya ningún cirujano le quiere ver aquí.
No, a surgeon wants to see her here. And
Porque ya le han sacado muchas veces sangre y necesita irse para Washington a hacer una cirugía de emergencia y ya no se lo hace por sus hermanos, ¿no? Porque no tiene quien los cuide.
She needs to have an emergency surgery. She needs to go back to Washington to have it, but she doesn't want to do it. Judge, that's what I was talking about, and I'm looking. I think that did she have a transfusion also? Una transfusión.
Bueno, ya está mejor. Ya mi hija ya está mejor también.
Okay. One of the children is anemic, and she had a transfusion too. So, Judge, at this point, I am asking the court to give us either maybe send us to ADR. Maybe we can talk some sense into both of them, between Mr. Davis and myself and the mediator, and how, because what I know that according to Mr. Davis, that the children are not before you, but if we have a guardianship, then we will make it part of it. But since we don't have any guardianship, then you're the one that has jurisdiction over the kids now, because I put it in my pleadings. I can't serve them because they won't understand, but they are before you, in my opinion, at this moment.
Mr. Davis, would you agree that a mediation in this case might be beneficial?
Yes, I would agree with that.
I don't
get it done quickly.
Yeah, I don't see another way. I don't have enough information to act accordingly, and I think that that might be the best option in this situation. The court wants to send both of y'all to mediation immediately. Who do y'all recommend that's available that y'all may know? I mean, obviously, you all are involved in mediations much more than the court. You know, you all go to these lawyers much more frequently than I do, and in terms of scheduling, I mean, can y'all come up with a couple suggestions that I could then appoint someone?
If Mr. Davis would like, I've had very difficult cases with Andy Almaguer, and he's just, I see how he's gotten really well in these mediations. If he wants to try Andy or whoever he likes.
Yeah, I use Andy quite often, so I wouldn't have any problem with him.
All right, let's do Andy Armageddon. I'm sure he can accommodate us as quickly as possible. Let's try to come back in 3 weeks. You think Andy can accommodate you all in 3 weeks?
Yes, Your Honor. I have some dates already on another case.
Yes, sir.
All right, let's come back on the 30th of March.
Okay.
At 9:30.
Yes, Your Honor. Thank you for your time, Your Honor. May we be excused?
Yes, thank you
Have
so
a
much.
blessed day. Thank you.
Thank you, Judge.
Mr. Davis, I'll call you on the other case we have pending.
Oh, yeah, they said they'd log back on at noon.
Yes, thank you.
All right.
Mr. Lopez, are you available? Greg, are you available?
I am, Your Honor. Good morning.
Good morning. This is in the matter of the marriage of Mario Sanchez and Talia Ramirez.
Correct, Your Honor. Greg Lopez. I represent the petitioner in this divorce, Mr. Mario Alberto Sanchez, who should be present by Zoom, Your Honor.
All right. Mr. Sanchez, is that you on the iPhone?
Yes, this is me.
Okay. And Talia Ramirez, I think you're also present.
Yes.
Perfect. Yeah. All right. All right. Can I have both of you please raise your right hand? Do each of you sort of tell the truth, the whole truth, and nothing but the truth, so help you God? Start with Ms. Ramirez
Yes.
and Mr. Sanchez.
Yes, I do.
All right. This is set for final hearing. I have a note here. Ms. Ramirez, did you retain an attorney? That's the note that maybe you were going to be looking for.
No, I didn't. I spoke to his lawyer about the amount to come to an agreement.
Okay, so y'all are able to, we're able to come to the, you're ready to proceed?
We're ready to proceed, Your Honor. I think we have an agreement on most things. I would like to put testimony on about the portions of the agreement, because I think we're down to an issue of arrears. But Judge, there's some housekeeping matters before I proceed with the testimony on what the agreement for this divorce is that I'd like to bring up.
Okay, go ahead.
All right, Your Honor. These parties have now have 3 different cases that they've been involved in. And I was doing a last minute search on Odyssey to see where we were on this. There is a Title IV case under cause number F3130-138 with an entry date of January 23rd, 2014. Judging by the case number, I believe this case has been transferred to County Court number 8, even though it originated in another court. And this would be a child support case. That's for the benefit of the parties. Also, Your Honor, under cause number F4690-13-H, there's a final decree of divorce entered October 8th, 2014. That would be when the parties first were divorced. And then after they divorced, they again got married and they separated soon after that. And that brings us to this case today, which is F4146-21-8. So I need to submit an appropriate order, Your Honor, to consolidate the 2 previous cases into this case is what I believe needs to happen.
Okay.
All right. So that is not written down in a motion, but I am making that orally right now to consolidate both those 2 cases into this.
What would you be consolidating though, Mr. Lopez? If they remarried, why would we need to reconsolidate anything from F4690-13H, which is the divorce in 2014, unless there was separate property or things of that sort that carry over?
All right. Now that you said it out loud, Your Honor, that makes sense. That case can just stay on its own. It doesn't need to be consolidated into this case.
Right. I mean, because unless there's something there that one of your parties or both of the parties are asking to continue. In other words, there was a determination of separate property. There was a determination of, things that would have to carry over into now so that it would make it easier so that we can make that judicial determination. I just don't see why if they remarried, we have to treat it any different.
You know what? I agree, Your Honor. None of those issues were in that divorce decree. So then the request made previously to consolidate that divorce into this divorce will be withdrawn.
Now, the Title IV case, I can see that being consolidated and being incorporated by reference into this one, but then you just incorporate the language of 3130, 13:8. If the children are still minors, if there's, any orders that you're wanting to take as part of that. I mean, I could see that, but.
Okay, that's correct, Judge. That one will be consolidated into this divorce and incorporated into this divorce.
Perfect. Okay.
And I'll submit the appropriate order.
All right. Then if you have any questions for your client, you may proceed.
All right. Well, Mr. Sanchez, can you please state your name?
Mario Sanchez.
And Mario Sanchez, you are here seeking a divorce from Ms. Talia Ramirez, correct?
Correct.
Yeah.
And prior to filing this divorce, sir, were you living in the state of Texas for a 6-month period?
Yes.
And were you a resident of Hidalgo County for a 90-day period?
Yes.
Now, you and Talia were, as we mentioned earlier, had divorced on or about October 8th, 2014.
Mm-hmm. Yes.
And then you remarried her. What is the date of the remarriage?
2018, October.
October 2018.
Mm-hmm.
All right. And you separated, sir, on what date?
Right. It was within that same year.
Well, let me tell you what Talia has told me, because I've been talking to her this morning. Your date of separation is October 29th, 2018.
Yeah.
That was your date of separation. So what was your date of divorce, sir? Or your date of marriage?
Wasn't it it was in May, around that time, no? I don't really recall, I'm sorry.
All right. But it was in 2018, correct?
Yeah, yeah.
And it could have been about 3 months before your date of separation, correct?
Yeah. Yes.
Okay. All right. So those are the dates we're going to use. Okay. Now, you and her had, at the time of your first divorce, you had 4 children: Mario Alberto Sanchez Jr., Arlette Dayanara Sanchez, and Aidan Arael Sanchez, correct?
That's 3.
I'm sorry, you had 3 children at the time of your first divorce.
Yes.
And then after that divorce, another child was born. That child's name is currently Edani Castro, correct?
Yes.
And a DNA test was obtained by you and Talia, or you agreed to a DNA test for that child, and that DNA test was obtained August 2018, and the probability of paternity that you are the father of this child is 99.999%, correct?
Correct.
So in this divorce, we're asking that the court, or you're including this child as a child of the marriage.
Correct.
And among the requests that you're making today is that this child's name be changed from Edani Castro to Edani Sanchez.
Correct.
And that the birth certificate or all vital records reflect that change and indicate that you are the father of this child.
Correct.
All right. Now, moving on. You and Talia have agreed that your child support amount should now be $3,220 per month.
Correct.
Which is as per the Texas child support guidelines.
Correct.
And you're willing to testify today, sir, that your monthly income exceeds $9,200.
Correct.
All right. And you are asking that your child support obligation of $3,220 per month begin March 1st, 2022.
Yes.
Okay. Now, as far as division of assets, you and Talia have agreed that you are to keep all items, personal property, bank accounts, vehicles, retirement accounts that are in your possession
Yes.
or under your name.
Correct.
And that she is to keep similar items that are all in her possession or under her name.
Correct.
And during this short marriage, sir, you two did not accumulate any debts that the court needs to divide, correct?
Correct.
And you have agreed to joint custody of the 4 children, but that Talia will designate the primary residence of those children.
Yes.
And you are asking that you be allowed visitation with those children as per the standard order in the Texas Family Code.
Correct.
And just to be clear, you want your times of visitation to begin at 6 p.m. on the first, third, and fifth Fridays of the month, and every Thursday at 6 p.m., correct?
Correct.
And you'll be returning the children on those weekends of visitation at 6 p.m. on Sunday
Correct.
and 8 p.m. on Thursdays.
Yes.
All right. Now, I'll pass the witness, Your Honor.
Right. Ms. Ramirez, do you happen to have any questions at this time?
Yes, I wanted to know, is he's gonna pay the amount of the difference since 2018 that we separated on the kids? Since he did not comply with the change on his income every year when he would change his jobs. He wouldn't do he didn't notify every difference since 2014. But on 2018, since we had Edani and he knew he was the father, he never gave me nothing for her. He never helped me with her. So I want to know if he's going to be giving me the back pay on Edani and the difference on the kids.
Okay, Mr. Lopez, obviously, if he has been established as being the father, I'll let you answer that question on behalf of your client.
All right, well, and this was a sticky point in this case, and Talia, correct me if I am wrong about what I'm about to tell the judge. What I think she's trying to explain to the court, Your Honor, is that she's making a claim for child support arrears.
Correct.
Because of that little girl. And while I know the court cannot be a mediator on this case, that is where we are stuck, Judge, on the amount of arrears. There's been an offer and counter offer, and we do not yet have an agreement. But I would like to get her on the record, Your Honor, and ask her if she agrees to all the other terms, and that is still what we have left. Because I at least want to nail down all the other terms, Judge. So
Right.
that I
No,
know
I can understand that. I can understand the importance of that. And then we come back and we try to establish the arrears.
Correct.
Let's do that. Ms. Ramirez, do you agree on everything else with the exception of that, those issues of the arrears?
Yes, the amount, the 3,200 were already including the deduction of the medical. I just want to make sure that's correct. Because we done I think it was like 3,600 minus the medical round there, it comes up to 3,200. That's including the deduction of the medical.
Ma'am, my client has offered you $3,220 per month in child support. The order that exists previously, we'll call it the Attorney General order, already has medical support in it. So my client will continue to pay that medical support.
Okay, so he's separate. Okay.
We're only talking about child support.
Okay.
So the medical support won't change?
Correct.
Okay.
So on the medical support, he will still be paying for that separately on the other order, right? That will not change then?
Ma'am, we're only talking about child support and offering you the child support of $3,200 per month.
Yeah, I'm not.
My client has a previous obligation for medical support that's in a Title IV order already.
And that will continue.
And that will continue, okay?
So they're not gonna, I'm not gonna lose the Medicaid for my kids then on the other one, or on this one. They're not gonna add it because I know they deduct it from it.
That I can't offer you any advice, ma'am. That's legal advice as to whether or not whether you would lose it or not lose it.
Because I'm sorry, I don't want the amount on mine to change. If not, that's why I'm asking, like.
The amount of child support may affect it, whether or not you qualify.
Okay, so then, okay. So, but not the Medicaid is like, that's my question on the.
The problem is that Medicaid shouldn't be viewed, ma'am, as something that you rely on. It's a taxpayer funded program. And your obligation is to try to get off of that as quickly as possible. It's a crutch, right? And you only use the crutch when you have a sprained ankle. You shouldn't be using that crutch when you are able to run, so to speak. And so I don't want you to be looking at it as I don't want to lose my Medicaid, but I want the most child support and the most medical support possible so that I can not lose the Medicaid, if that's the way you're looking at the world.
No, like I'm saying, like, I just wanted to be on record that he'll be reliable for the private insurance, just in case if I lose that Medicaid. For the kid.
He's responsible for insurance.
Yeah. Okay.
Yeah.
Okay, I just wanted to be like, like he's gonna be the reliable for the private insurance for the kids.
Yes, that medical support is always going to be a responsibility he will have to pay.
Okay.
Whether you qualify for Medicaid or whether you're going to have to apply for some other, children's health insurance program, CHIPS or something of that sort, you may have to move into that program.
Okay.
All right.
Yeah.
Now, any other issues with respect to anything that Mr. Lopez has discussed?
Okay, so how's the insurance gonna continue then with the kids? That's just my primary with the kids, their insurance. That's my concern, because I have a son that he has ADHD and I have to be taking him to the doctor.
Talia, maybe I can answer that question. Well, let me ask you some questions. Can I ask her some questions, Your Honor?
Go ahead. Yes, go ahead.
Okay. Ma'am, please state your name, your full name, please.
Talia Ramirez.
And Talia, did you hear all the questions that I asked your husband regarding child support, division of property, division of debts, and the change of name for the youngest child? Yes?
Yes.
If I were to ask you those same questions, ma'am, would you also agree that that was the agreement that you and Mario reached today?
On changing the last name and the divorce, yes.
On all the issues, all the questions that I asked of Mario, was that also your agreement, ma'am?
Yeah.
Okay, thank you. Okay. And you're willing to sign a divorce decree with those terms, correct?
Okay, yes.
All right, good. We're making progress, Talia. Now, the only issue, as I understand it, ma'am, was the issue of child support arrears, correct?
Yes.
All right, and I'm gonna ask you for some testimony on that.
Okay.
All right. As you think of this, you had told me earlier that Mario should be liable to pay $200 per month in child support arrears for the youngest child, and that was supposed to begin November 1st, 2018.
That was October when you left. Yeah. I thought it was $200 because that was the total of I was getting before.
Ma'am, I'm trying to make it as simple for you, the court, and my client as I can. Okay? You had told me that your position was that Mario should have been paying $200 extra per month for the youngest child beginning November 1st, 2018. Correct?
Yes.
That's what you told me, remember?
I said.
Okay. And so your claim for child support arrears begins at that point, $200 per month, beginning November 1st, 2018, all the way to the present, correct?
Okay, yes.
And if we count the number of months, ma'am, from November 1st, 2018 to March 2022, you and I agreed that those were 41 months, correct?
Yes, correct.
And so this is a mathematical problem, correct? It's $200 a month times 41 months of child support arrears, correct? But you said, I also want to add 6% interest on that because you understand that 6% interest is the interest that child support arrears carry, correct? Ma'am, yes? And did you calculate what those amounts were? I'll give you an opportunity.
Yes, it was like, we ended up saying 8,600. It was a total plus, it was an interest, which was a 6%.
Okay, what numbers do you have, ma'am, for that?
It was, the difference was like 516. That's like 6% of the 8,600, if I'm not mistaken.
Okay.
Yeah.
Did you multiply $200 times 41 months?
200 times 41. Yeah, that's 8,000. Oh, I'm sorry. I think it was with the interest is at 8,600 something.
Okay, ma'am.
Yeah,
And now I'm confused myself. Okay, you already said that you want $200 a month and 41 months in child support arrears.
It was 200.
And that's 8,200, correct?
Yes.
And that to that, you want to collect 6% interest as well.
Yes.
So that is 8,200 times 6% interest, 8,200 plus 490. And I come up with $8,682.
8,682. Yeah, it was 8,082.
$8,692. Do you agree, ma'am, that that is your claim for child support arrears?
I don't agree with the 8,692. I don't agree. I had spoken to you that if I had seen that it was a 12,000. Let me see, because it was 12,000 on the arrears.
Okay. Hold on, ma'am. That's fine. That's fine. You don't agree. That's okay.
No, I do not agree.
That's right. But that's the calculation we made, but you do not agree. The judge just needs to know that, okay? Your Honor, that is where we're stuck on that issue. May I ask my client other questions?
You may.
Okay, Mario, did you hear what we just discussed regarding child support arrears?
Correct. Yeah, I did.
Did you understand the calculation that we made?
Yes.
Do you agree, sir, that you owe her child support arrears beginning November 1st, 2018 for the youngest child?
Yeah, I agree.
Do you agree that you owe $200 per month beginning November 1st, 2018?
Yes.
Because you have not paid child support for that child, correct?
Correct.
All right.
How did you come at $200? Was that an agreement?
No, that was okay.
I can explain to the court, Talia.
Okay.
Explain to the court. There was another person, I don't remember his last name, but his name is Daniel, who thought he was the child's father, judge.
Okay.
And this other person was paying $200 a month in child support as per a court order, something that I don't want to expand on today. When that man found out that there was a DNA test, he stopped paying the child support. And so Talia is saying, I'm entitled to those $200. And my client doesn't disagree. He says, I'll pay it.
Okay. So I guess the confusion here and what should have done in the prior order is somebody entered into an order without a DNA test? Yeah. Okay. I mean, let's not reopen that, but therein lies our problem. right? Our problem is that a court entered an order without a DNA test, probably on the presumption that both parties accepted that he was the father and the mom said that this was the father, and they forewent that step of DNA test, which would have basically cleared up this whole confusion. Okay. So what do you not agree with then, Ms. Ramirez? If the other person was paying $200, I guess your argument is he should be paying more?
Yeah, I just want it to be whatever it's accumulated on the arrears on him. It's
Right.
12,000 because he stopped.
How do you arrive at 12,000 if I multiply 200 by 41 times 41?
Oh, because it was actually 270, but they would deduct the medical, and then they would do it all together. It's including the medical. I don't know if that makes a difference. I have the paper where it's accumulating with arrears and interest and everything, like the arrears with interest and the medical all together. It comes out to 12,000. I have the paper from the attorneys from the child support, where he was giving the payments and he stopped paying it since when he found out he was not the father. He stopped paying it. So I have all the paper with all the payments and all where he stopped paying it. And I feel that Mario should be paying.
Did you return that money to him? To the other?
The other 12? No, he paid for it, but there's another 12.
Right.
pending.
No, but did you return any money to this person who ended up not being the father?
No,
Why not?
the first 12, no, because we were back on and off together. On the first, when we were doing the child support, the first, before me and Mario got married.
So let me get this straight. You knew that there was a possibility that the other person who was paying child support was not the father.
No, I didn't know that it was like, he would mention it to me, but I was like, I don't think so. I was like, oh.
But ma'am, you had a relationship with Mario Sanchez when you were dating or with the other person, or you had a relationship with both of them?
Not really, no.
How did this pregnancy happen?
It was because this person cheated on me, so I cheated back on him with Mario.
Okay, so you knew that there was a chance that this happened. This could happen.
There was a chance. There was a chance, but
You didn't return the money back to the other person, right? Okay. I'm just trying to figure this out for you. Okay.
Yeah.
All right. Mr. Lopez, with respect to let's just assume that I accept the $200. I mean, there's so many moving parts in this case. I mean, there's so much issues about whether or not money should be returned, but look, if no one's making a claim for it, I'm not going to make or force Ms. Ramirez to do that. That's not our issue. That's not our issue here today. But she needs to be mindful of that, right? Before she starts, coming in here claiming to have clean hands. This is the unclean hands doctrine that we all learned in law school. So here's the thing. Let's just assume 8692. How do you suppose that judgment get paid? Mr. Lopez.
My client has agreed to pay those child support arrears at the rate of $200 per month beginning March 3rd, 2022.
That would be, how many months are we talking about? 41? Right?
Well, yes, it would
be 41 months.
More or less, yes, Your Honor. Obviously, there's some interest that's going to be, paid, so it may be a little bit more than 41 months, but yes.
All right, Ms. Ramirez?
On the reason I didn't return the money to Daniel was because we have another child and he's already 3 years old and he has not paid child support for that.
Okay, I mean, I get that. And that's fair. That's fine. I don't want to get into it, but I was just looking at the morality that comes from me understanding your position, right? Yeah. Of asking this gentleman to ask for more money. Look, the court's of the opinion that I think it's hard for me because the only information I have right now is here's a bigger problem. And you don't have a lawyer, right? It's hard for me to walk this tightrope and not give you legal advice at the same time. I think the last time I gave you enough time to retain a lawyer who might have suggested that you do certain things, but you didn't do certain things, which was to make a claim for arrears in the amount that Mr. Sanchez was obligated to pay. And that's not before the court today. If you can read between the lines, what I'm saying is that I can't just arbitrarily go back and ask Mr. Lopez to hand me information about what his client was making between the period of November 1st of 2018 and March of 2022. And so that's something that a lawyer would have to file with the court, and I can't just arbitrarily give you that or do that. But that's the importance of being represented by counsel, right? Now you might say, well, I don't have the money for it. Okay. But if it's not before the court, I can't consider it. And therein lies where I think we are at, where they're agreeing to pay $86.92 in what's called a PP2, a payment plan 2. They want to pay $200. I think $300 is more reasonable because it shortens the amount of time to pay that off. And that's kind of what I'm looking at, Mr. Lopez, at 300 versus 2.
All right.
But without more information, Ms. Ramirez, my hands are tied to consider any other information, even though I know that if I were representing you, I would be looking at this completely different than how you. I know what you want. I just can't. It's tough because I can't do it for you.
I have a question. Is he gonna pay the arrears on the kids since he didn't do the difference since 2018? He was only giving me $309 a month for 3.
Oh, so you're saying there's additional arrears?
There's additional on 2018 since we left each other.
For the
He was
kid?
giving me $309 for 3 kids a month.
Well, how do I even establish what his child support about? He never paid you at all, or he was only paying?
He never notified the difference since 2014, but since we got married in 2018 and we left each other, he was only giving me $308 a month.
And why should, okay, and what
on the first?
What information do you have that it should be more, or was he not paying you that?
He was paying me the $309 a month, 308, but he never notified to do the difference on his income change since 2014.
Did you file a motion to enforce or a motion to modify?
I did do it through the child support, but they never did anything. They just saying the case was there, but they never did anything about it.
Okay, well, if nothing was ever filed, then there was, the moment that you file a motion to modify, then I can go back to the date of filing of that motion. But without that, I can't go back.
Okay, so then he's not gonna pay no difference from 2018 since.
Unless there's a motion, but I don't know if there's a motion. Mr. Lopez, as an officer of the
Judge,
court,
I'm
was there ever a motion to modify or filed by the Attorney General's office to modify, or even if there was not a final order, was there ever a motion that I could go back to the date of the filing of that motion?
No, Your Honor, I've reviewed the Title IV case that I referenced earlier, and I reviewed it right before the court's hearing. The last thing that happened on that case was there is a final judgment after non-jury trial entered January 23rd, 2014. And there is an order on motion to transfer and consolidate entered January 18th, 2017, but there is no motion asking for a modification.
Right. So that's what I need, Ms. Ramirez. That's what I'm looking for. I'm looking for a modification that was filed by you, your attorney, or even the Attorney General's office, but somebody.
Well, is there a way he can just show up his income tax returns? I have most of them, and just give me the difference or whatever it has to be from 2018 that we had left each other, since he didn't do the change since 2014. I mean, it should be since 2014, but I mean, 2018.
And on this divorce, Your Honor, all she filed was what I would characterize as a general denial. She didn't ask for any affirmative relief. Even though, you know, we've agreed to, we've agreed to a child support terms. And Judge, very important, at the beginning of this hearing, the court was very careful to ask her whether or not she had hired an attorney, or, and I may be paraphrasing at this point, or whether or not she wanted to proceed.
Right. So here's a situation, and I want to basically be really clear, Ms. Ramirez, because I don't want, look, Mr. Lopez, I think, has gone beyond his duty. His duty is to his client. His duty is to represent his client zealously. Your duty is to defend yourself and to represent yourself. But when you don't know what to file, and when you don't make certain claims and you don't file certain pleadings before the court so that I could then consider certain things, then I think you put yourself at a complete disadvantage. And Mr. Lopez is here to represent his client. And I think he's kind of right at that line where he's trying to make it work for purposes of this, of appeasing the court, to kind of help the court try to finalize this case, to try to help you. But I don't want him to step over that line and affect himself with his client. And that's where I think he's on that line right now. And without going any further, I think you have a choice to make, Ms. Ramirez. You have a choice to make, which is to kind of accept what they're offering, or ask me for more time to hire a lawyer. And but we already went down that road, right? Last time we were here, we went down that road. I don't mind giving you 30 more days to try to do that, because I think Mr. Lopez could work with any lawyer that is hired on this case to try to help resolve this case in a way that is fair to both parties. But to ask him to do certain things, I don't want to put him in that position, because it's not his responsibility, and I don't want him to feel like he's doing it to help the court out. I am stopping him before he makes that commitment, because I don't want him to, because he has a duty to his clients and he is doing what he needs to do, and I see it. So you have a choice to make, and that's to A, accept the offer, or B, ask me for more time so that you can hire a lawyer. And if you ask me for more time, I'll grant you 30 days so that we can come back and see where we're at in 30 days and see if a lawyer has been retained. And just know that your requests have valid points, but you got to file something with the court for me to be able to entertain that. And you just can't ask Mr. Lopez to do it because it's the right thing to do. He has a duty to his client as a lawyer.
I'm thankful, Mr. Lopez, but yes, I would like more time.
Okay. Again, I hope that you appreciate the situation that Mr. Lopez finds himself in.
Yes.
All right. He finds himself in a very unique position. He's not doing what he's doing to hurt you in any way. He's just doing it because he's representing his client, and he would do the same thing if he was representing you. Okay. Now you just need to have a lawyer to represent you so that we can all kind of put everything in the middle and put everything before the court so that I can consider the facts. Right.
Yeah.
I'll grant you 30 days.
Okay. Thank you.
April 6th. A little under 30 days, but we'll see where we're at on April 6th, okay? Mr. Lopez, thank you for your patience. I know that you've been working hard to try to see if something can get resolved. In this situation, I think that there's some issues that she still has, claims that she could still possibly make, a discovery that if was given to you, you'd have to respond to, things of that sort. But I know that you just can't hand that over to her because, unless she files her own motion, in which case she's representing herself, then she could, but I just don't know if she's aware of what should be done, how it can be filed, and then doing that on her own.
I understand, Your Honor.
Okay. Any other questions, Ms. Ramirez?
No, thank you, Your Honor.
You have some homework to do. All right. Thank you, guys.
May we be excused?
You may.
Thank you.
Do we have any announcement on number 2?
No, just can you make an announcement?
Yes, CL 19-1504H, Portfolio Recovery Associates versus Angel Perez. This case was set for default judgment. No one appeared. This case will be set for default
Yes, on the 6th.
on April 6th. DWAP, April 6th, 2022 at 9:30. All other cases have been handled.